Well, hello, everybody. I'm sure the microphone's working. Can you hear me okay?
Yeah.
Okay. My name is Eric Reifschneider, and I will be the moderator of this panel discussion coming up. Let me begin by telling you how we're going to spend the next hour and 15 minutes. We will start with a brief round of introductions. We will then go into Q&A session where I will ask the questions and my esteemed panelists will provide the answers. I've organized the discussion around 3 topics. And in doing that, of course, the idea is to bring out the industry perspective on these issues of SEPs and FRAND licensing, as opposed to perhaps the government perspective or the academic perspective. Our objective here is going to be what happens in the business community in the world of sorting these issues out, getting agreements done, or perhaps, if not, ending up in court, getting the disputes resolved that way. So I'm mindful of the fact that many of you have been for the last 2 days at IPBC, and have heard a lot of these subjects already discussed at length. So in doing this, hopefully I will find a way to ask at least 1 or 2 questions that nobody else has asked the last 2 days. That might be a tall order. I'll give it my best shot. We will save the last 15 minutes for Q&A from the audience. So you will have your chance to ask the questions that I didn't ask. So with that, let me, and the 3 topics of the discussion that we plan to have with the panelists. The first one is the question of component or supplier level licensing, as opposed to licensing the end product. The second topic we will get to is the question of injunctive relief and other remedies available to a patent owner in an SEP dispute, and how the availability or lack thereof of those various types of remedies factors into the perceived problems of hold up and hold out. And then the last topic will be determination of FRAND rates in terms of the license agreement, and how is that done? How should it be done? So with that, I will start the brief round of introductions. Again, Eric Reifschneider. I am Senior Vice President of Strategy and Business Development at Marconi, where I have been for the last nearly 6 years. My role at Marconi is to help working with my colleagues in the creation and growth of independent licensing platforms, which are market-based solutions for licensing on a collective basis, patents, usually standard essential patents, to a large community of product manufacturers or service providers in the relevant markets. For those market-based solutions to be successful, we need wide participation from both patent owners and product manufacturers or service providers. So we need to take all perspectives into account. So let me begin. Eeva, I'll start with you on the far right, and ask each of the panelists to briefly introduce themselves.
All right.
Moving in my direction.
Does this work well? Yes.
Yeah.
And I still have some voice left after 2 days in air-conditioned rooms and screaming, on top of everybody else's conversations. Eeva Hakoranta, very happy to be here. Thank you for inviting me, Tim and Kirti and Justus. I have been in the standard essential patent space for maybe some 20 years. I revealed, I think on 2 days ago that, I was not planning to, work in IP because I didn't think that that was sexy at all. So, but, here I am, and I ended up in this field, and I actually love it. And I think, the best part of it is that I think in this field, you get to work with the smartest people in the world. So, yes. So now at InterDigital, and I want to say one thing about InterDigital, because I think it's important, in this discussion and in this context, because we're talking about something like the innovation ecosystem, which Kurti also, I think, brought up in the beginning around the standards. And for us, we're a research-based company that practices in standards and standard setting. We're creating technologies, and then, the only source of revenue that we have is, from getting the interest or the sort of return on investment from monetizing those innovations. So when we talk about sort of the pricing and the value, we have to remember that, let's not do it so that it excludes universities and research-based companies from that ecosystem. So that was the point that I wanted to make.
Okay. Thank you, Eeva. Let's try to do just introductions.
Which is unfortunate. She gave me a perfect lead in on the scholarship side, but I'll keep it short for you. My name's Kent Baker. I recognize many faces here from not only the days when I was at Qualcomm going back to the 1990s, but when ETSI meetings had 8 people attending. That was the IPR committee. So yeah, I've been around a little bit. After that, I went over to PARC, which is Palo Alto Research Center, which any of you on the technical side will know it as a prolific innovation hub. And I was in charge of trying to take those out of the R&D centers and try to get them into the marketplace and running into patents along the way, as well as creating patents. Currently with u-blox. u-blox is an implementer. We make the wireless little creepy crawly module that goes in pretty much every wireless implementation for the markets that we serve. So we not only know the technology better, but I can give you a great insight on not only what you have to do in implementing a standard to actually make a marketable product at the very fundamental level. So given that, I'll pass it on.
Good morning, everyone. My name is Mathias Hellman. I'm with Ericsson, and Ericsson is a leading provider of cellular infrastructure in the world, according to Gartner at least. We've been in this space of providing these products for nearly 40 years. The company is much, much older than that, but we've been around since the early 2G days. My role with Ericsson is doing IPR strategy and also managing the patent portfolio that we own. And in that capacity, I'm deeply involved in some of our negotiations, at least, and trying to figure out how we can reduce friction, get more business done in between all stakeholders, essentially.
Hi, my name is Mang Zhu. I am with ZTE right now. I'm the head of the patent asset management team, which is responsible for managing the whole ZTE Corporations and some of the subsidiaries' patent portfolio, including essential and non-essentials. And before that, I was working for Motorola Mobility, and my lifetime was identified as SEP patent expert, at least in Motorola. And I started to build our 4G portfolio since 2002. And unfortunately, Google bought us. So then I joined the Lenovo. And later on, because the Google sold us, so then we start to build the 5G portfolio. And then in 2017, I joined ZTE and start to work on ZTE's 5G patent portfolio. And that's all probably my experience. And my team also support licensing and litigation from patent point of view. I mean, like patent support. Thank you.
Thank you. Very good. So as you can see, we have a wealth of experience and a variety of perspective on our panel today. Okay, so first topic, components or supplier level licensing. And I'm going to start with kind of a threshold question. And I'll direct this question. Each question I'll direct to an individual panelist. The other panelists are then free to chime in if they have a different or contrasting view or just an additional point to make. But I'll address this first question to Mathias, which is is this even still relevant? I mean, after the court decisions coming out of the Ninth Circuit and Fifth Circuit, and Qualcomm FTC case, and in the Continental Avanci case, in light of Huawei and Nokia settling their case in Europe involving this issue, is it really still relevant, or has it basically been settled?
It's a good point, and I think there are a couple of dimensions to this. It's a great question. A couple of dimensions. One dimension is, of course, that it's indeed so that we've gotten more clarity on these points from courts, but it's not from all relevant jurisdictions, right? Particularly, it's been discussed and judges has thought about this in Germany, here in the US, and that is very, very true. But I want to go back to the industry perspective and kind of connected to negotiations and what's going on in between, at least rational parties, the way that I see it. Licensing level, and if you also will, the value, small saleable patent practicable unit and all those concepts, they are natural things for companies to discuss in order to bargain with each other on what the value should be, who should be the one paying, what is the right way to size the royalty for an application. That is our perspective. It's not something new. It's been around at any point in time when new entrants are coming to our market, which happened in 2G, 3G, 4G. It's happening now. We don't only see new regions joining. We also see new industries coming together and converge around becoming connected. So if I have to kind of guess, we will still be discussing this issue 10 years from now at a similar conference, maybe with some new faces, most faces still around, because I think it's it's one of those fundamental things that are brought up in order to kind of keep I don't want to use the word devalue, but it's one of those things that you do in order to negotiate to keep your own royalty base as low as possible. So that's my view, I guess.
So, implicit in what you were saying, Mathias, I think, is a perspective that, at least in some cases, the push for component level licensing is really sort of an effort to reduce the price, reduce the royalty cost. But there are a wide variety of different types of technologies and standards and end products, and maybe in some cases, the efficiencies and so on would be different. So let me ask you, Eeva. It's interesting. I don't think it's a big secret that some of the major patent owners, like Qualcomm, will license below the end product level, at least in some instances. Others, such as Nokia and Ericsson, have been pretty steadfastly opposed to doing that. Why is that the case? Why do some do it and others have been very resistant to doing that?
Without expressing any sort of insights into anybody's strategies as such, I think there can be very many reasons for it. If I think about sort of the sort of logic in deciding, on what level you would like to license your assets, for for standardized products, I think there's a couple of things that come to mind. From a licensor's perspective, there needs to be a fair value. So I don't think the fair value can be connected to the component price. It should be connected to the value of the innovation bringing to the particular product vertical, or the consumer using it. So the value could be different in, say, automotive and a stupid dumb smart meter, for instance. And then there are other considerations. For me, it makes a difference that I know which products in the market are licensed. So visibility, to which products in the market are licensed is actually a very important consideration. for some licensors, maybe not for everybody, but for some licensors. And it's not always a given that if you license, for instance, at module level or a chip level, you're not given that visibility to where those modules or chips go. So, then it sort of makes your price differentiation very difficult in that in that situation. There's the question of sort of who gets to decide. From a licensor's perspective, when you're operating a standard essential patent program, a licensing program, you have to be consistent, and you have your obligations to license on a fair, reasonable, and non-discriminatory basis. So if you don't have that visibility, it's actually quite difficult to sort of maintain that aspect of FRAND in place. So maybe I'll just pause there, and somebody else might have something more to say about this.
Well, it triggers a question in my mind for Kent, actually, because, look, anybody who's been in the business of managing or working in a licensing business, has encountered plenty of situations where, the licensees are not exactly jumping for joy at the prospect of taking a license and paying licensing fees. And yet, as I understand it, Kent, u-blox has been a little bit more, proactive as a module supplier at the component level, and in some cases, seeking out licenses. And I'm curious, as to the extent you can discuss it, why that's the case, why u-blox has taken that approach, and to what extent, if I might ask, do indemnification obligations between the supplier and the customer factor into those types of decisions?
Yeah, you can imagine I was sitting here pulling my fingernails out with some of the comments, because I always find it interesting when you ask a patent holder to explain from the implementer's perspective what we face in a licensing negotiation. Now, on the other hand, with u-blox, we're unique. We do license. One of the things that was beaten into me at Qualcomm, Fabian, was that you are entitled to a fair return on your patent. You put the R&D dollars in, you're entitled to a fair return. This is a fundamental concept everyone should grasp, but I think some people lose it in the details. Now, we're licensed to Qualcomm, we're licensed to InterDigital, we're licensed to Philips, and we're licensed even to some patent assertion entities. I'm constantly asked, why can you do this where other companies are not able to do it, or they reach an impasse? Well, our quiver of licenses show that we are a willing licensee to begin with, and that's a philosophy I brought in to u-blox, also had over with Palo Alto Research Center, because you are entitled to a fair return. But that fair return is where it gets stuck in the kind of in the details, because it's not just the amount you're paying, it's also the terms. Now, one of the things that is proven to be extremely effective is what Eeva just touched on. When we have a licensing negotiation, we don't play games. As anyone who's been in a licensing negotiation with us, we're going to show you our products. We're going to show you our profits. We're going to show you our market segments. And much to the chagrin of some companies who don't like to hear this, we do not believe that the chip is the smallest saleable patent practicing unit. That is not where the royalty should be based. Why do I say that? I don't say it because it's political positioning. Luckily, my CEO does not tether me to the company policy when I speak. So at this point, I should probably say these are my personal views, not of u-blox. Anything I say that sounds silly, stupid, or otherwise is due to jet lag, because I've been bouncing around a bit. So give me some leeway. But when it comes to the value, if you do take a look at what some of our product goes into, which will be commercial and IoT products, the smart meter for your electrical house implementation, we built the very fundamental wireless product that goes into it. That smart meter is not going to do much more. It's going to send data. It's going to send data at the greatest efficiency time for the network. It can do it at 3 in the morning, 4 in the morning. It can do it bursty. It can do it slow. It can do it a variety of different ways. I was an engineer at one point, so I can at least touch on the technical part, but I'd have to ask Curdy or someone else to step in if we get too far into it. The other products that we service, some are very elegant. Some do have the ability to take the wireless connectivity, build on top of it to get that product into the marketplace. Because I can tell you, if we only built a module that read to the standards essential patents of a standard, we couldn't sell it. Shocks a lot of people to hear that. That's not the way it works in business. Likewise, when we have a company that we go to, and I have companies, even in this room, that I have approached and said, we want to take a license proactively as an implementer. We want to negotiate a license with you. They said, no, we will not license you. The problem with that is a lack of understanding of how the development at the module level works to even get an implementable product. If I don't have a license, I don't have in the US the patent rights to practice that patent. I cannot then develop something that fits the situation the customer is asking for. If they have the patent rights, I become a conscript. I can only make a module that fits the parameters of the license they have negotiated with the patent holder, but I'm not allowed to see that license, which means I have to go to their build specs. Many times, the person who wants to build the end product does not understand the wireless connectivity well enough to know what it is they really need. They tell us what they want. Then we go in and we spend about a third of our profits on R&D not related to standards. We are a standards participant, but a lot of R&D is spent on developing post-standard to make an implementable module for their specific situation. Depends on what spectrum they're using, depending upon all sorts of government regulation, depends on what the use is. Well, that's something we have to go ahead and protect. For example, in driverless car implementations and like that. I'm not sure most people realize we're seeding the development at the module level in automobiles or the driverless car pretty much to Chinese developers. Why? The unsurety behind IP, the development of the market and like that is leading most Western module manufacturers to say, I'm not going there. My 5-year strategy will not include development of that. Now, the other thing before I give it back to you, this is supposed to be short, but I'm on my preacher's platform here. How many people in the room work for a company with valued at 500 million or less? Okay, there's a few. That's many more than usual, because normally what I'm doing is I'm talking to companies who at the standards level are global companies. And I can tell you their perspective on standards issues, whether it's governance or otherwise, vary wildly from ours. But that's a different topic.
All right. So Ken said a lot. There's a fair amount of unpacking to do here. And I'll just warn the rest of the panelists, the more you say, the more you're ripe for follow-up questions.
Perfect.
And I will not be shy about asking follow-up questions. Let me start, and I want to get Mang into the discussion here. Let me start with more of an empirical question that will factor into some of the things you said, Ken. And other panelists, feel free to chime in on this as well, because this is just a knowledge and experience-based question. Are you aware of any situations where a component supplier has been restricted through some sort of injunction or exclusion order or the like from developing or selling its product as a result of standard essential patents?
The only litigation in the world I've seen is really the Continental case, right? So if I understand your question, because Avanci tried to license to the car in the Continental, ask for Nokia license for the component level license. And
right. In my understanding, others may know as well or better, but Continental initiated the lawsuit.
Right, right.
There was never a patent infringement case against Continental, so there's, of course, therefore no risk of an injunction or the like against Continental.
No, probably it's a very long question to ask me because I'm not a lawyer, not aware what's the lawsuit happening, but I do have comments on the components. Can I say that?
Of course, go ahead.
Because I wanted to talk about technology. So I think components has totally different components that, in the world, and different levels of components. Can be components is a chip or can be a component. It's pretty well done product. So as a SEP licensor, and we not confused to all the components level license, but we have to value, like Eeva said, we have to value what the value is. So and also patent we have different SEP patents. It's not all the patents will only concentrated on the component level of the things. So if you are licensed only, we will be under risk. We did a risk analysis. We will have some patent risk if we only license to the component level, because we don't know, just like Ella said, we don't know where the components were sold to, and the other party they sold to may have, license, they have patents, and we always do bilateral cross license kind of stuff in order to protect our patent rights, their patent rights, and also to be fair, and also to be not on the, it's a risk control issue, right? So we don't want to later on somebody come to us, hey, we have SEPs, but my components already licensed. But still, there's another thing is the patents. So the patents, I'm writing patents. I mean, like I'm a patent. I really like patents. So, so I can write a patent, can read on components level, even for the SEP, and as well as read on the device level. Do you want to pay us 2 times? I mean, that's something component guys, all the device guys need to think about. So, and also I have to mention, so for Sylvia, I'm so glad she is in the audience. So we worked together before. I remember the time she had a training to the inventors, first, the newcomers to the company in the Motorola time. And he was talking about the patent, how to write the patent, how to write a claim. So she particularly said, a claim, you need to consider where the infringing device level, which level that is. You don't want to write a claim only about the display, but you want to write a claim including the device which has that display stuff in it. So patent is an art. So you can write it as you want, but also, fitting the patent law, right? So this is my comments on the components.
So it's interesting, I think. Go ahead. Mathias.
Can I build just briefly on this? So I think you bring up excellent points, and you talk about the grant back, right? And if you are selling products that we do, I just want to contrast that it's complicated, right? We are putting out $20 billion of products on the market that are also utilizing the standards. I will never be able to get a deal done unless I can speak to how it's going to affect our ability to continue to sell products in a good way, right? And the fact that you give away your rights, you license someone, and the customer of that party may then be a patent holder that might affect you later on. That's a very big consideration that we need to take into consideration when we do this. And the other part that also, just to show how it's complex, it's exhaustion, right? So you bring up that the patent claims can be written in multiple ways. Our patent portfolio is very diverse. So doing an exhaustive license on a component level is not necessarily possible. And I think as a patent holder, we would want to see, smooth licensing with small, let's say, friction, and I'm searching for the word of transaction cost. And it, for us to doing multi-tiered licensing where we chop up our portfolio depending on where it's infringed and where it's utilized, that is not necessarily something that would be in our interest, let's say. So, my experience based on these two things is that taking a value chain approach and kind of work with the value chain to find out where we can have, the interest intersect to find a good solution with all these complexities is really what will bring industry forward, as opposed to just, standing in our corner basically and shout about what we think our own position is.
And also added on the value. So I was picking an example, the professor or whatever, he was talking about the ring bell, that he can see, her daughter. I didn't catch it until he made the ring, the bell stuff. Think about, if you look at the component, it's just a transmission, right? But the Wi-Fi. So, but it brings value to the ring, the bell, do you think the bell really infringe? Yes, it does, right? Because, and it's adding the value. Without the Wi-Fi, you cannot sell the bell. So this is my point. I mean, anyway.
Yeah, so there are, I think, two themes that the panelists have touched upon. One is price or value, and the other is efficiency, transactional efficiency. Let's focus on price first. Do you agree or disagree? I'll ask everybody to give a quick answer to this.
That's impossible.
Not much more than yes or no. Do you agree or disagree?
We can vote.
With the notion that if you are licensing at a component level, that the value and therefore the price of the license should vary depending on what kind of end product it goes into. Or should it be the same across the board, regardless of the end product? Eeva?
I get to go first. I do agree that, you know, there should be price differentiation.
Okay.
I'm trying to keep it
Yeah,
short.
very good.
So I don't get lynched by my fellow competitors. I will tell you, yes, we do agree that there is a difference between the value implemented in a smart meter, between that and the value implemented in some other device. Commoditized devices tend to have tight margins. Other devices like luxury goods do not. And there are certain enablements that go in a luxury good emanating from the wireless that you will not ever find in a smart meter. Things like that. So yes, I'm going to go on the yes side, although I will be lynched by my counterparts.
Okay.
Yeah, great. So I also agree. It's important for, you know, uptake and adoption of cellular standards, which is really important for Ericsson in order to continue our product business. So we think that price differentiation is key for achieving this.
If you can very well sufficient do that, the answer is yes. I doubt if you can do that.
Okay, great. Well, that's the perfect segue, Mang, to the second dimension of this, which is transactional efficiency. So, Mang, one of your comments was that you can have both component level claims and device or system level claims. And so even if you licensed the component, you would, and Mathias made the same point, you would still have other patents at the device level that would need to be licensed to the device manufacturer. So does it make sense to, you know, have, and is it workable to have two levels of licensing? Or is it better to just license at the device level once and for all? And does that leave any exposure still for the component supplier in a meaningful way? Kent, let's start with you on this one.
It's going to take the rest of the session to answer this. If you look at the reason we even have standards, going back to the earlier panels, it's for deployment of the standard, and you make that FRAND commitment. If you talk about standards essential patents, there's a cost that comes with it. And when you're talking about a component level for the implementation, yes, it does make sense to license the SEPs at that level. Now, I'm a patent attorney also. I know about claim construction, and I know why 80% of the patents out there are garbage is because they overly claim and they do not stick to the technical elegance. When you apply this to a standard that first comes out like 3G to 4G, there is some reuse where you have incremental improvements, and those are patents that should be narrowly drafted. When wireless first came, like when Qualcomm first did 3G, this was revolutionary. Those patents have high value and they were broad. They're drafted differently. Is it possible? Yes. I mean, if you're a patent attorney, lawyer, engineer, you got all this all together in every negotiation, it would be an easy discussion. So it is possible to do it. It does make sense. We don't maintain for a second that when our wireless module goes into something like a luxury good, there is not additional value in the patents you hold, or in the deployment in the network to make it more power efficient or like that goes far beyond our module. Are there inefficiencies in licensing? You come to us and license, especially since we serve the IoT field, you've got 1,200 customers right there. That's a huge efficiency. You're not going out to each one of our customers, and you're not going to sue them either because they're little and they represent 95% of the market out there. And that's what people just don't quite grasp yet on the patent holder side who don't want to license at the component level. And these are not comfortable licensing negotiations. Some of the people in the room here who've sat down with me, we tended to differ on valuation, but we figured out a way to make it work.
So Eeva, if you have someone like Kent who's coming to you saying, I want a license and I'm willing to pay, and I recognize the value is, different depending on the end product, and I'm the risk of putting myself in your shoes or speaking on your behalf, and I'm willing to take a field of use license, where I'm licensed for modules only to go into this kind of product and not that kind of product. Does that help mitigate? You talked earlier about the visibility problem. Like, I license these modules or these components, I don't know where they end up in, and then exhaustion kicks in and it's a big mess. Can you control that through field of use licenses sufficiently, or is it still unworkable?
Field of use licenses is certainly one way to go. And, if I have somebody like that, coming in, I will certainly, listen very carefully and, try to work out the solution that works for both. That's, that's the first element. I don't think that, simply just field of use is, a full answer to, visibility to which products in the markets are licensed, because, ultimately, when you have a program and you're trying to license, a given market, you may have to go and sue someone in the market. And, you're quite right. The patent holders don't want to sue component makers. We just don't, it doesn't make any sense. It's often the end product makers that are the target of those lawsuits ultimately, if they are unwilling licensees, because an SEP licensor does not want to sue. That's always their last resort. We don't want to sue anyone. We would just like to get the licensing going and the licenses done. So what we're doing now in the IoT, I think now is the time when that market starts moving ahead, and we need to find solutions which, help the industry proceed without having every case resolved in a courtroom. So field of use, Mathias mentioned that, granting exhaustive licenses at component level is not necessarily a great way to go, especially for those companies who sort of have products of their own and, they need the reciprocity. It's not going to help them with the end product makers, if they've sort of granted exhaustive licenses at component level to their suppliers and so forth. I think you need multiple you need multiple different solutions, and I don't think that there's going to be every license is not the same. There's no one size fits all. It's a lot of tailoring.
Okay, one more question on the subject, and then I'll try to move on to the remedies topic. But I can't help but ask. Now the ball is back in your court, Ken. Let's suppose Eeva's willing to give you, non-exhaustive, assuming you can do it. It's not the easiest thing in the world, but non-exhaustive rights within a field of use. Does that sufficiently address, your business objective, especially if nobody's really suing you in the first place or threatening to sue you? Or do you feel you need rights not only for yourself, but also to pass through to your customer?
Yeah, one of the tricks is to go ahead and make sure that the patent rights we have for making our product do protect our customer at that pretty much restricted level. You want to put something more elegant on top of it, then you should have to pay for it. Now, one thing that gets missed in pretty much every licensing discussion I hear, you can find out what products they're going into and not just do field of use. It's called an audit. And I don't know any license I have that doesn't require an audit. Some are extremely detailed. And I can tell you, there's also an overhead with even doing the audits. Qualcomm, many times we'll have somebody who comes to us, or we've got something that doesn't fit into what we've licensed. And we say, we can't really figure this out. So I pick up the phone, I give them a call and say, this is what it is. Give them a ton of information, both technical, product level information and like that. They take a look at it, they'll come back and we'll have a discussion. Does that fit? Does it not fit? What do we do with it? That's the type of robust exchange that takes place, and yet it seems to work. Like I say, we're licensed with InterDigital, and one of the conversations when you're talking about what you're licensing, what are the products? Show us. Show us, are these really commoditized? Are they not? Too often in negotiations, I see people talking, taking positions. I also see this at the policy level at any standards group. They take corporate positions, dig in, and where's the proof? Show it to us. Well, we're more than happy to show you that. I think that's a success for why we can license.
I will just point out, and I'm familiar with the kinds of things you just said, and that was my job in a prior life. There are times, though, when products go through distribution channels where it becomes very hard to trace them and figure out where they ended up, depending on just how generic the product is. Okay, remedies, injunctions, and other remedies for patent infringement. I wanted to start by asking, and I'll put this one to Mathias first. From a licensor patent owner standpoint, Mathias, is there anywhere in the world you think you can go these days and assert your patent and seek an injunction and have an injunction issued and go into force without the FRAND question having been considered and addressed by the court and taken into account as part of the decision on that remedy?
It's a great question, and it requires someone to know all jurisdictions and how they work in the world. So I don't, and I think actually, given the development we see also in different jurisdictions, the answer and how you answer that will vary over time, right? So just sitting here now, I can't give you an affirmative answer, but I do think that most courts are applying rigor, and they won't issue an injunction without kind of a rigor around the merits and the facts in that particular case. That tends to be my view on it. But again, I'm not particularly involved in assertions, so maybe there's someone else that know more about that.
Anyone else, Eeva?
Can you repeat the question so I
Is there-
can put my concise answer to you?
Can you, to truncate the question in a more concise manner, is there anywhere you can get an injunction without the court or tribunal having first considered the merits of a FRAND defense?
I don't think so. I don't think so in the standard essential field. I think it's actually very difficult to get an injunction in this field. Most courts, they use various techniques. Some in Germany they are sort of having their competition law based tradition. They look at whether the offers have been FRAND, and if they have not, then the injunction follows. In UK, they have developed a different view. Nobody knows what China is going to do. I'm going to be provocative here. I'm going to say that that's a jurisdiction which is supposed to be a civil law jurisdiction, but ultimately there is no rule of law. So, we don't know what they will do, and, we don't know how the rest of the world will react to that.
Mang, do you have anything to say?
Anything related to it's like legal questions, litigations. I'm very hesitant. Just like Mathias said, I cannot read everything. But I think in China, at this point, they are also looking into FRAND first. And also, I would like to add it on it, not answer your question. In terms of FRAND, in Germany has a very clear rule of how you do, and you will consider claim, kind of clear rule. So that's how they attract so many people going to Germany to do litigation. It's only my opinion, not my company's position. Wow. So, but in the US, I hope. US is kind of fuzzy, right? Correct me if you guys have other questions. I don't see there is a very clear thing saying what we're supposed to do, and to show the other side is unwilling, then we can start the litigation. Sounds like we can just start litigation right away.
Well, there are certainly not a Huawei ZTE like regime in the
Mhm.
US. You were very diplomatic though, and not really addressing Eva's provocative comment there at the end. So I'll let that pass. You know, you hear a lot of talk from the SEP owner community that injunctions are really necessary in the case of an unwilling licensee, and without it, you have rampant holdout, and the whole system breaks down. The question I have, I'll start with you again, Mathias. Sorry to be picking on you, but if it were clear that injunctions were available in a situation where the court has determined that there's a valid and infringed patent, and the patent owner has satisfied its brand commitment, would that be enough? Or, you know, if the defendant, the implementer, can take the license to avoid the injunction at the last minute, you know, does that still leave you at a disadvantage? In other words, do you need more than an injunction actually to make it work?
It's a great question, I think, and the way that I tend to see it is that if you, at the current state of play, basically, where I think generally, just generalizing, we are at that stage where, you know, you have to go to court and you go through the whole procedure, and in the end of that procedure, you're still supposed to make one of your friend offers available in the court to that potential licensee to settle them. I think what happens is, though, that you remove the incentives to negotiate, because it's rational, right? If you know that an offer is always going to be available to you, why don't try and see what happens in court? Maybe you find something, maybe you can develop something that really gives you a better position in the end. So that's an economic kind of risk analysis that you need to do, an options analysis. You know, what is the cost? What is the potential downside? If the downside is no more than my initial position, then I think it's rational to go that way. So I do think that if there aren't incentives to negotiate before you go to litigation, you will see it more and more. Then the question, you know, we can then debate, is injunctions the right thing, which you know, has consequences for markets and so on, or is it going to be a financial increase that you're not entitled to the brand offer anymore, or that should be a set increase? I don't know. I think there are better people to assess that, but I do think there has to be something to increase the incentive to negotiate and not take it to the courts too easily.
I mean, this is a pretty important point. So let me ask, or at least give the opportunity to both Kent and Eeva to chime in on this also.
We do need more. We do need the courts to develop penalties on holdout in the SEP space. I want to say that you know, we have some regulators out there, you know, who are sort of thinking that if we address the so-called transparency problem, licensees will start, you know, flowing in, and, you know, licensing will start happening. That's not going to be the case. You know, we don't have a transparency problem, which is, you know, at that level. If we start imposing something like essentiality checks on SEP holders, that's just going to be one more step in the friend dance. I think we need incentives to negotiate. So we need injunctions, and we also need court-imposed remedies on making it a level playing field, so that those who actually take willingly licenses are not put in a worse position than those who have a strategy of holding out and forcing the SEP holders to enforce their patents in courts. I was getting a little emotional yesterday. This is now going to be a little longer. You know, I'm sort of yesterday when we were hearing. When we were
have a virtual gong.
Yes. When we were hearing that, you know, patent holders, you know, sit on their patents for 10 years and then they assert them just before they expire. I don't think that's what we do. We are actually trying to negotiate amicable licenses. And all of those parties who think that we sit on our portfolios, and then suddenly assert them, are those parties who do not want to resolve, do not want to take a license. I'll stop there because you're going to hammer me.
Before I say, or tell you what I want to say, I just want to take one step backwards on the distributor thing you talked about. That is an issue about if this is part of the business side of modules. Sometimes you do sell through distributors, and just like a license is a piece of paper in a contract, you have one with the distributor. It tells them who they can and cannot sell to, what that end product use is. If there is not an audit procedure in place to keep them honest, you have problems. It was just reported in the Swiss press, didn't deal with royalty rates, but a u-blox module showed up in a Russian drone in Ukraine. As a Swiss company, we have strict restrictions, no military use for our product. But a European distributor somehow distributed them into Russia. So we are now proactively prosecuting that to shut it down. So this is part of that relationship I'm talking about. There's some red herrings out there to licensing where people say, oh, we can't do this, it won't work, blah, blah. Sit down and have a meaningful discussion with the right people in the room, and you might find a way. Now, on the injunction side, I have some very, very strong views because injunctions, especially against small companies, give you tremendous leverage in a licensing negotiation. On the other hand, I've seen patent abuse by potential licensees that we're doing holdout. Now we're a small company. If I don't get back to you for 2 months on a question, that doesn't mean I'm holding out. It means I'm swamped. If you need something faster, ask for it. But still, the traditional holdout, there needs to be something, because I do know some companies that I've spoken with that are small, and they don't think they're ever going to get forced into a courtroom. And that's just not fair to the patent holder, because you are entitled to a return on that investment.
Okay, so let me ask a question or two that kind of are aimed at how is it you end up in the courtroom in the first place? And if you do, then how should it play out? So I'm moving now a little bit into the third and final topic, the setting of FRAND terms topic. Obviously, price is hugely important, and what most of the business level discussions center around. How much is the royalty? How much is the licensing fee? Let me ask first, are there other important terms in a license agreement? They're so important that they rise to the level of being a factor in FRAND, and ultimately being the cause of a breakdown in negotiations, even if price is agreed, where you might still end up in court. And Eeva, you probably have the most extensive negotiating experience of anyone on sitting at this table. So I'm going to ask you to address that first.
Thanks, Eric. I'll answer this, based on my experience. I do not have experience of a case where, the parties would have agreed on price and then would not have been able to agree on the other terms. I think the price and the value usually is, the gating question. And when you get to a level where you agree on that, you usually start working together with the other team in sort of finding the right arguments, on both sides to persuade the actual decision makers in the company to sort of work out a deal. That's not to say that there's not other important deals. There are very many other important deals in a FRAND SEP, license, but usually there are ways to negotiate.
Can I just add to what Eeva said, because I think you're right. I mean, price is number one and center, but there are important other terms that kind of make a deal impossible to go through with. And those are very individual, but let me give you one example. So you have a deal you're negotiating, a running royalty, and the company, your counterpart, for some reason refuse to provide audit rights. So they will report in black. You don't know really where the numbers, if they're if they're right or not. That kind of, then obviously you will have to assess, is this a sufficient issue to go to court for? That's not necessarily certain, but it will definitely impact, your perspective of that deal, right? even if the price and the value then per unit basis is what you agreed to, if you have no view if they are actually paying for the whole sale or if they are cheating on you, then you know, so that they are, it might, maybe that is roped into price in your mind. I don't know, but these contracts can be, you know, very complex. Lawyers like to make it complex, and other business people too. So there are many things that needs to be agreed to. And I think what happens is that once you have price agreed, then we all work very, very hard together to agree to the rest.
I'm gonna kind of say not always.
Say one thing, which I think, you know, just building on what Mathias said, I don't want to say that price and the other terms would be separate, because they're not. You know, it's a deal, and you know, everything sort of implicates, you know, everything sort of works together. So it could be so that once you've agreed on the price, then the negotiation breaks down because something that you thought was included is not included.
I have to throw in my 2 cents, because when you're actually making the product and not just using the patents for whatever you're doing, you run into situations like this. u-blox does GNSS, we do Wi-Fi, we do cellular, come to us, we do your wireless connectivity. Now, if I build a module and I put GNSS, which is our flagship product, we're the best in the world at it. We just came out with the smallest module that's available for a GPS locator. But if I go ahead and I want to put that functionality and co-locate it on a module with a cellular connectivity or a Wi-Fi, why am I paying more in royalty to the cellular license holder? Well, we actually make 2 separate units because of that IP issue. We can do the GNSS with no royalty and sell it at a higher price and profit margin just because of the elegance of the solution than we can the cellular module. But if I put the 2 together, which we've had a lot of demand over the years for that, to go ahead and reduce the physical footprint on what's going to be the end product or the board that goes in the end product, my IP rate went up on the cellular side because my percentage royalty is higher, because the unselling price is higher. Now, if someone can explain that to me, let me know. Because that cellular is not enabling anything. We're not sharing antennas, although that's not currently possible. But we're not sharing antennas, we're not sharing amplifiers. Why is that possible? Now, on the other side, fairness, if we do the reasonableness on the royalty, you still have fairness and non-discriminatory aspects. I see an equal amount of unfairness and discriminatory practice with licensees as I do with licensors. That's a deep topic. I'm happy to talk to anyone about it, but I don't think we have time because most people don't understand that it runs 2 ways.
Yeah, that could consume another 3 hours or discussion. So I'm going to ask one last question, and then we will turn it over to the audience for their questions. But there seems to be a consensus that price is the most important element of the discussion. And often when price is agreed, everything else eventually falls into place. There's generally, in my experience, been a consensus that there's not one single price in any given licensing transaction that meets the requirements of FRAND, that there in fact can be a range and different types of prices. You mentioned percentage of selling price, but it could be a fixed amount per unit, sometimes just a flat amount per year or an upfront lump sum. Many different ways to skin that cat. So in a situation where it's one thing if you have an implementer who just doesn't want to pay, won't return the calls, won't reply to the emails. Say you have a patent holder who offers a license at a reasonable royalty. The implementer thinks it's too high, they counter, but they're doing their best to negotiate in good faith, and they counter with a royalty proposal that is also within the range of FRAND. And yet they can't come to an agreement, and they end up in court. What should happen in that case? They both made a reasonable offer, but they still haven't come to an agreement. How should a court work that out? I know it's a tough question, but therefore it will be my last. And I see Eeva kind of. So I'll start with Mathias.
Again, Eeva, please, if you have a strong opinion, go ahead. Okay, so I mean, first of all, I think it's an intriguing question. And I do think that in those circumstances, I do think a settlement will happen though. So the question is, will it never be a relevant one? Because if you are kind of close to each other, it should be possible to work that out. But though, from a theoretical point of view, as a patent holder, you're the one committing when you do provide your technology to the standards. And I do think that is really what counts here, that I am then fulfilling my commitment, whether the other side or my counterpart is also, you know, within a range and being a willing licensee. That is certainly something a judge, I assume, would take into account. But it would be very, I can't in my head really kind of wrap it around the idea that someone else's price would be the one that I have to accept as a property holder. In a negotiation, of course, it's a combination of those two. But you know, in this very specific example, I would lean towards that. If you have made a FRAND offer, then the implementer or the licensee in this case ought to accept that, I think.
Kent?
I'm going to toss it to Eva for a second.
He just wants the last word.
Or more time to think, perhaps.
Okay, so here's what I think I think it's a hypothetical scenario too, because I do think that, if they're both in the FRAND range, there will be a settlement. The parties will work it out. Either they will agree, or they will ask for a mediator to help them do it, or they will agree on arbitration. Because usually, in my experience, the problem arises when the other party does not want to resolve. That's when you end up in court. You do not end up in court if both parties want to resolve.
I agree.
And
I said I agree, because whatever you said, for me, you cannot define two friends. So so either one way or the other, right? In the end, I just say I agree
Okay.
with Eeva.
All right.
yeah, and what I was struggling with is the two different scenarios between the license renewal versus taking the initial license, which are two very different scenarios. But if someone comes to us and their only basis valuation is comparable licenses, and we actually look at who they're licensing, seldom do we find they're comparable. But the reason I think we have come to agreement is because on both the patent holder side and our side, we found a common valuation methodology. And like, I'm a big fan of the entire market value, which that's not my area. That's the one thing I'm not as an economist. But there's different approaches. And if we can get together on either a combination of the approaches or one approach we all kind of like, then we usually find that we are paying more than we might have thought originally in our calculations. It's called learning when you're having a discussion, and we learn from the patent holder, they learn from us, and that's how we reach the agreement. Because we have litigated, we filed litigation, but we've never had to complete it because we usually find something in the middle, some agreeable FRAND valuation. Because you're correct, there's no one value for FRAND.
All right. Well, I certainly enjoyed that. I hope the rest of you did too. But we have 10 more minutes, perhaps a little bit more. People don't mind being late for lunch. So let me turn it over now to the audience. Sure, there must be questions. Please don't be shy.
Thank you. So I'm Gustav Brismark. I'm an ex-Ericsson person. Know many here in the room, but for those who don't know me, my question is also around price, and I agree that price is predominantly what you negotiate in these agreements. But obviously, arbitration would be one way of agreeing price if it's in between two parties that want to reach a conclusion. So my question is really, do you have any experience, to the panel, do you have any experience where your counterparty says that they would like to resolve the price issue through arbitration, but then comes with prerequisites that are making the arbitration unacceptable as a route forward because it contains other parts that would make it impossible to accept that proposition, like, for instance, making the whole procedure public or something?
I can start. I have experience of arbitrating friend situations, different experiences. Some have been in context of renewals and agreeing on sort of what the value should be for that renewal. I've done one arbitration where the parties actually negotiated a full agreement, a first ever agreement, all of the other terms in that agreement, and then decided to sort of leave the price, for an arbitration to resolve. And I also have experience of those situations, Gustav, where your counterpart, in principle says that they're willing to arbitrate, but then the terms of that arbitration become so onerous that there's no sane person in the world who would actually sort of agree to those terms. And for me, that's really not a willing licensee in that situation, because they're imposing terms which are so difficult to accept that it's going to be a broken process to begin with. So it's another sign of constructive refusal.
I can add two short things. It's a great question, and arbitration leads to a deal in the end, different from going to a court, which is a dispute in a sense. But you will have a contract that's the goal, right, with a price, and there are that also creates some tension, I guess, when you want to go into arbitration, because the payday will indeed come at one day when you have to honor that. So we've seen parties wanting to basically put in a floor and a ceiling on what the outcome could be, which is very, that could be agreeable, but that could also be something that frames really what the arbitration panel could do. But there are also instances where we've been approached with an arbitration proposal, and everything is sorted out except the price. But then they insist on a valuation methodology, or a methodology on how to decide the friend price that kind of is inconsistent with what we think is the best way to do it. Basically, let the two parties argue their case and see what the panel goes with.
And being the company that's usually being asked for the arbitration, we come back with those unreasonable terms. And they're usually things like, now tell me how you actually got to your friend valuation. Tell me what you actually spent at the standards group. This is why we do not agree to arbitration, because the discovery rules do not mandate that you have to have that degree of transparency. And that's the most overused word I've heard in standards, is transparency. I like to use meaningful transparency. Show me what I need to understand where you're at, and I'll pay it. But if you don't show it to me, because confidentialities don't let me show you the comparable licenses, you're asking me to blindly believe you, and you're not blindly believing me. So that's why it doesn't work for us the way arbitration rules are structured.
I'm going to comment on that, because
let me ask a question first. So from your comments, Kent, I gather u-blox has actually entered into a number of license agreements with patent holders around these different technologies and standards. If the patent holder were agreeable, would you be willing to publish those license agreements unredacted on a website?
Out of respect for some of the terms in the licenses, I would say no, and it's not to protect u-blox. You can remember, a license is just a contract. It's what you want to put into it. And sometimes we come up with some pretty creative solutions on how we're going to make ends meet. And you're not going to find it in another license. So it would have to be both myself and the patent holder who are going to agree. Remember, my licenses aren't just between me and the party that we're arbitrating with.
Well, I know.
And that's it. Now, redacted, maybe that would work, but then I think you're going to struggle over what are you going to redact and what aren't you going to redact? And you're going to get a piece of paper with lots of black, a price, a couple terms, and signature lines.
Well, the more you redact, obviously, the less transparency there is. But if you have all these sort of creative solutions in every individual license agreement, aren't you basically saying that comparable licenses aren't that meaningful and aren't that relevant?
No, it's not what I'm saying at all. Because comparable licenses, think of it as, and jump in here, this is kind of the economic side. No one thing predominates. Comparable licenses, we look at those. And then we try to determine, all right, what are the facts really? Are they comparable? Then we take a look at an economic approach. What is the market for our market segment? What is that going to permit? Is it a commoditized product? Is it a non-commoditized product? Then also, what other enablements are brought? Because this will bring me lots of heat away from this conference. I've got a cell phone. It'll take a picture. I've got the same cell phone that will send a wireless connection. Now, is there value in being able to send that picture over the wireless connection that exceeds the value of the wireless connection when they're separate? Yes. Now, a lot of people say, oh, no, that can't be because the camera is so elegant. That's absolutely true. And you realize that the current camera photograph that's being taken on a phone couldn't be sent over a 2G connection. There's value. Now, how do you separate the market value from the good marketing campaign and the sales and the ability to actually integrate the two things together from just the wireless or the wireless plus some value because of whatever that additional was? And that's really what the discussion should be. But the discussion right now are global companies taking policy positions and saying it's smallest saleable unit, it's comparable license. No, that's not it. Both are wrong. So comparable licenses are important. I think that they are a bellwether. I was there when it was the only tool we used, but it's not controllable.
Okay.
I do want to comment because I've done a lot of arbitration. I've even written an arbitration award, myself. So arbitration is not confidential. You can tailor your confidentiality rules in an arbitration, and you certainly can, have appropriate discovery in an arbitration. And my friend arbitrations have included sharing information about comparable licenses. And, I would like to sort of demystify this part of arbitration because I think it's important. We hear so much about arbitration not being transparent. So Eric's question to Kent, would you be willing to sort of publish those agreements that you've done? Most companies don't want to, and I'm meaning licensees. They don't want to publish them. So we should be transparent about the reasons that we don't like arbitration. I think the primary reason may be that it really commits you to something that the arbitrators will resolve for you, and that's what I want to say. It's again, it boils down to a question of willingness. I'm not saying that there couldn't be a genuine disagreement on the terms of arbitration between two parties who are otherwise willing, but they will sort out their license in some other way.
Curry?
Can I ask something? So this might be a very simple, basic level question. Okay, so everything is about price. Eric, you said everything is about price, and I think we can agree to that. So if everything is about price, it has to be that the price doesn't change based on where you are selling a product, or in this case, based on where you are negotiating a license. It shouldn't change. As you know, one of my colleagues like to say, friend equal friend, right? You sell a cup to Mang or to Kent, the price shouldn't change. So if that's the case, I really want to understand, Kent, why would a component manufacturer need a license? Because the patents that you need are already in the public domain. It sounds like what you need is indemnification, right? You need assurance that you won't be sued. And then the question is to Eeva, Eric, Mathias, and Mang, why is it not the case that is a part of wherever you choose to license because of efficiency, because of price constraints, because of accountability, right? Because you need to observe how many units are being sold to be able to actually enforce a license. As a part of that, the component guys get what they need, which is assurance that they will not be sued, right? Super basic question, but that really gets to the point.
I think there's two parts to that. Indemnification doesn't really solve anything except how much you don't pay at the end of the day, but pushes it right back to price. And this is where we're going to disagree. There is not one fixed price for FRAND. Even when I was at Qualcomm a long time ago, we never said there was one price for FRAND. There is a range of prices, whether it's Nash's game theory you're using in economics to try to do it. Now,
Okay.
the end
but
product it's used in.
quick
You're going back to your
interjection
cup.
there.
Let me finish.
Okay.
Gertie, we let you speak. Let me finish. We get into this all the time. Don't worry, guys. That cup you give me, if I use
And I
it
would
to-
say we're past time, except it's Curry's conference, so.
if I use that cup to drink my coffee out of, it has a value for transporting the coffee, not burning my hand and allowing me to drink it. If I take that cup, stick a string in it and make a communication device out of it, like we all did, or many did when we were kids, at least in my era, it just became a communication device. Are you telling me that cup doesn't have a different value in the two applications? The cup's standardized, but I'm using the same cup for two different things. But what value do I put on it as a consumer?
Okay, so I have to clarify, right? My point is that from a licensor's perspective, what they need to get is regardless of where they license. And it has to be the case.
When you
And-
say where, do you mean at what level?
About level, right? Like your basic question of this panel was component level licensing, level of licensing. So it's, why is it relevant if wherever you license, you get the same ROI? The problem is that you don't. And my question to the rest of the panelists is, why is it?
Are you avoiding me now? Gertie? Because I have a great response for you, because when's the last time I ask a patent holder, how do you determine its FRAND? What is, and ROI is not always an accurate indicator, but what profit are you making off of that R&D investment you made? Are you making a profit at 10-fold, 15-fold, 5-fold? I know I lose money. At the end of the day, when I do an accounting sheet, I'm losing money if I don't sell something at a profit. If you look at IP at a price point, there's a point where you're making either some profit, more profit, or a lot of profit. I'm not saying which it is. I'm saying there's no transparency to know it. And I've never had a discussion where you could actually say this is FRAND because of, and that's why the whole economics issue came up, was trying to price it based upon other factors that are used in a different field to pull it in for a price point,
Okay, let me
or
try
reasonable
one
price
last time.
points.
Because we are talking across each other completely. I have a very real basic question. What do the component manufacturers need? And what would it take to give them what they need?
With many of the license, so even Qualcomm, we have what we need and we know the price of what we needed. So it works for some companies. I don't know why it's not working for others. If you don't think you're making money off of the royalties we are paying you or making enough, then you can go ahead and raise the royalty rate in our next negotiation. If you think you're making too much, we're happy to take a return check, which by the way, has happened before when you reduce the royalty rates. So it's working.
You know, Curdy, you're, I mean, you're, it's, well,
I think, but I think, but I think, you know, I guess there are colors there, but you know, I think my point really, I actually said it already during this panel, you know, the patent holders are not going to sue the component makers. You know, they need an immunity from being sued in order to sort of sell their products to the end product manufacturers. We usually, yeah, we usually, exactly. We usually, you know, in end product licensing, you know, we provide something like, you know, have made rights, and that should cover, you know, the component makers. But some component makers, you know, do say that, you know, they need more than that. And I think that's part of the problem, you know, in this dialogue, you know, because, you know, there are differing views on that, you know, why do you need more? Because you've granted indemnifications and, you know, your OEMs are requiring you to indemnify, and you know, then those indemnifications probably have been granted without factoring in the price of the IP. You know, and this is the big issue that has sort of at least taken the automotive industry so long to resolve.
are there any other questions? I think one more,
May I? Yeah.
please.
Okay. So Joachim Henkel, Technical University of Munich. About this question of licensing level, I would have about 20 comments because I just wrote a paper on this, and if you're interested, I'm happy to share it. Eric, you asked the question, is this question still relevant at all? Because courts have decided, usually in favor of the patent holders. And Matthias, you added, judges have thought about it. Yes, they have. But I mean, from an economics perspective, that question remains highly relevant. And So I've done research with a focus on smaller licensees in the IoT space. And my impression is it's just a huge transaction cost because of two things. First, the sheer number, there may be, I don't know, thousands, tens of thousands IoT device makers, each have to take licenses from one or well, probably more, maybe tens or hundreds of licensors. And second, they have no clue. They don't understand the technology, the patents, the licensing process. So both work to create high transaction costs. And my impression is that that just doesn't work. At the same time, Matthias, I totally agree with you that some implementers, they favor SS PPU licensing because then they look at the smaller price of the unit. And that's also not fair. So here I agree with Curdy, what you just said, that should be independent. So maybe one should really separate the level of licensing from the calculation of the price. And that might be a way to actually do component or higher level licensing like the u-blox without tying that directly or in a naive way to the price.
So is there a question in there somewhere?
No, I wanted to save time, so I just made a comment.
Okay, very good. All right. I will not keep you from lunch any longer. Thank you to our panel.